Hey, good afternoon. Thank you for showing up. My name is Vince Aprile. Some of you I've already known. Well, most of you I think I've already met, but and I'm not going to bore you with anything except to tell you from Louisville, Kentucky, I appreciate the fact that you are, those of you that are public defenders, have been in for 30 years, and you can take the public, you can take the lawyer out of the public defender system, but hopefully you can never take the public defender out of the lawyer. And I still do some appointed work and things like that. I am in private practice now, probably still transitioning, as I said earlier, or yesterday. So that's a little, that's me. I know that some of you have heard some of what I'm going to talk about in bits and pieces in groups. I have to tell you up front that I'm going to, and we only have an hour, so I'm going to do this much faster than I did when I was doing the voir dire. I've got to briefly explain to you what I mean by theory and themes, what I mean by an opening statement, and what I mean about how your cross-examination fits into everything, and how we're going to do this particular kind of cross-examination. Are these things to improve your cross-examination, which I call putting the witness in context, okay? The first thing is, I hate to do this, I feel sorry I was heard it before. Arthur, maybe you want to go out for a few minutes and take a smoke break or whatever it is. But basically, I want you to think of it this way. This is the storytelling methodology of litigation. I said it before, and I'll say it again. Everything you ever try. If you are a part-time criminal defense attorney, part-time civil attorney, this works in civil cases, it works in administrative hearings, it works if you're representing juveniles. It doesn't matter that your fact finder is a judge. Such a version of it, either with regard to appeals, and when I do appeals, I plug it in a very similar way. It's obviously not as good for appeals. It's not as full of content in an appeal as it is here, I don't think. But so the storytelling methodology of litigation is very simple. The first point is this. Everything that goes on in the trial, every witness, regardless of who calls them, okay, that is the story that's being told. So why is that important to us when we're talking about cross-examination? Because if you sit down with your child, with your nephew, and tell them a story, what happens? You get, if you're making the story up, you get to decide who the characters are, right? But when you go into that courtroom, the way that our system is set up, the prosecution goes first, and they may, and they usually do, call characters that you didn't want to be in your story, right? So now you're stuck with those people, and you have to bring those, make those characters fit into your story. And in some of the groups we talked about this, you've heard of good facts and bad facts. There are no bad facts. There are only facts beyond change. There are facts that you are stuck with in your theory. If you cannot make your theory compatible with facts beyond change, what do you need to do? Get a new theory, right, exactly. So, now, that's the whole big picture. That's what you're going to present. That is hard for you to handle. I don't care who you are. I don't care if you're a genius. When you try to keep track of all of that, that's just too much as you do your decision making. For me, and the way, with this methodology of litigation, the theory of the case has to be something practical. I don't, you can hear people talk about theories, and when you get finished, you think, I know what it is, but I don't know how to use it. What is it? Does it fit in my back pocket? Do I put it in my trial notebook? And my way is you put it in your trial notebook. It's a paragraph of about 3 sentences. Oh, I should say this right now as people start writing things down. This stuff is not on the CD. I'm going to try to work out with Daryl and Rosie that next week I'll go back and email them electronic versions, and they may print them off and give them to you. If they don't, this is your backup plan, okay? If you want it, because if at the end of the hour you don't like it, you don't want to get it. But if you want it, you can always email me. You'll have my email address on the faculty list. just send it and say, I want the theory and themes handout, or I want the advanced cross-examination handout. I'll send it to you electronically. No cost for my postage or anything. You open it up, you got it, print it out, right? The other thing I got to say is, I can understand you got a lot of choices. You walked in here. If you decide, I don't need this, you want to leave, you want to hurt my feelings, okay? Feel free to leave. And if somebody wants to come in from another group, I will welcome. I will start over. That wouldn't be fair to you. All right, back to where we were. So, what is this theory? It's a paragraph of 1 to 3 sentences. Is that absolute? No, you could have 4 or 5. What you're really shooting for is to get a theory that'll fit on 1 page. This is 2, okay? But on 1 theory, 1 page in your trial notebook, and it's going to have 3 components. 1 component is factual, okay? You can't have a theory without facts, because you wouldn't be able to prove it. And remember what a theory really is. What's a theory? It's a plausible explanation for a set of facts. Whether you're talking chemistry, you're talking mathematics, or you're talking scientific hypothesis, or you're talking everyday life. What you're doing is creating reasonable doubt without saying reasonable doubt by doing what? An alternative story that satisfies all of the evidence and is a story of innocence or reduced culpability. And as Ann from Colorado, the instructor on opening statement, said, even reduced culpability, lesser included, that's still a form of innocence. I don't disagree with that. I just refer to it as you might be going for lesser, right? And in a death penalty case, we talk about the theory as one other thing, a sentence less than death, to get to a sentence less than death. Okay, and what is it? So we got factual basis. Now this is the one that gets left out a lot, the emotion, the emotional element. And I want you to ask yourself, we don't have time for me to just go into it and give me examples, but ask yourself, let me ask you this, how many people have tried cases here? At least one. Okay. Try to think back to the last case, jury trial, or even a bench trial, and you thought, can you figure out in your own mind, did you know what the dominant emotion was? You need to know that. You need to know the dominant emotion. And judges, a lot of academics, they try to tell you that emotion has no place in decision making. All the psychological studies, and it's total bullshit. The emotional way you decide, the emotion factors more into making any decision, no matter how logical you think it is, than any logical component. Emotion is what causes us to make it challenge where our decisions go. Sometimes it's not really clear cut to you that it's emotion, but it's there. All the psychological research says that.
So just real fast, what are some of the most common emotions that you use?
Okay, I will tend to use the same kind of examples over again because I picked examples so some of these people might hear the same example. But here's the way I usually do because it's so easy for you to get, for people to get. In a self-defense case, now self-defense is not a theory, right? That's not a theory of the case, but it is probably the legal component. That's the one we haven't gotten to yet, right? The third component. So in most self-defense cases, or protection of other cases, what do you think the dominant emotion would be?
In a self-defense case?
Fear.
Fear, exactly. Because what motivated the person to take this action? Fear. Now, is that going to be true of every self-defense case? I'm not going to say that. It always depends on what the story is that you're telling, right? But we could probably guess 99, 90%, something like that. Self-protection cases, it's going to be fear.
Now you said that self-defense isn't your theory because there's no facts in there. But if you
Because
outline it because
well,
so
let
and
me
so
just
was
say
afraid
this.
because this
Right,
guy had a gun.
Here's the deal. I said factual component, right?
Emotion.
That's the emotional component we're just talking about now. The third component is the legal component. Now, don't get confused that we're not talking about legal terms. We're not talking about legalese. What we're talking about is the common sense basis behind those legal defenses. Okay? So when you say in a jurisdiction self-protection, you're talking about self-defense, right? And when you talk about self-defense, you don't have to be a lawyer to know, or a legislator to know that if you're walking down the street, somebody comes up and threatens you, threatens your wife, threatens your children, threatens your husband, that you're going to stand up and fight for them, and you're not going to think that's morally wrong. You're going to think that's necessary, unless you're some fanatical religion that says, you know, I have to die first, or you're Maria Goretti, who wanted to be killed rather than be raped, you know, so she became a saint. Right, I don't understand it either, but anyway, you get what I'm saying? You get the idea?
Yeah.
Okay, so you're looking for the common sense basis in the story that supports the instruction that you'll get that will allow the jury to say not guilty. And sometimes that legal component is tied up in just reasonable doubt. You're not going to call it reasonable doubt, but the circumstances are going to be such as to so the jury will see, well, if I believe that, he couldn't have done it, right? She couldn't have done it. Does that make sense, or is that too abstract?
No, I think it makes sense.
Well, here's a good example. What if your legal defense is it wasn't intentional killing of the person, it was an accident, okay? Some jurisdictions have instructions on accident. Maybe yours does, but some don't. Some say, if you prove it's an accident, that is explained away by that creates reasonable doubt. You see what I'm saying? So you don't care. I mean, you care for submitting your instructions, but you don't care for what the law is directly. You want to talk about the common sense, the facts and the emotion coming together, this common sense justification that it wasn't a crime. Got it or not? Right? Okay. Then, let's see, what should I say? I probably should give you the way I've written it out. Put my hands on it. Maybe not. Here it is. A paragraph of 1 to 3 sentences which summarizes the facts, emotions, and legal basis for the citizen accused acquittal or conviction on a lesser charge, while telling the defense story of innocence or reduced culpability. You want me to read you one real quick or not?
Yes.
Some of these people have heard this before, I apologize. Let's do the Joy Burden one. Outraged and angered by the dramatic bruises that appear on the face, head, and body of 2-year-old Mary Smith shortly after she was picked up from the home of Joey and Karen Burden for babysitters that day. Mary's parents, the police, and even the examining doctor all assumed an assault rather than an accident, a crime rather than a fall, and that Joey Burden had hit and hurt the child. With little or no investigation and evidence, the police ignored and discounted the obvious explanation of the spectacular bruises on the fair complexioned little girl. A face-forward fall on the wooden front steps of the Burden's home, which produced no wounds, no bumps, and no bruising. At the time, Karen and Joey comforted and inspected Mary and assured themselves that she was okay. You heard a mini story of where our whole case is, right? Our defense is?
It was an accident.
It was an accident. The emotions are outraged and angered, right? That sort of thing. Be careful. Outrage and anger has to come from the story. It can't come from the way you feel to be defending an innocent man, or you would make every case the dominant emotion would be anger and outrage. Okay, so that doesn't really fit. Does that help you to see how to do it? Why do we want this? Because this encapsulates and summarizes, right, everything in this big story we're going to put on, and it helps us make all our decisions, from pretrial motions to how we're going to do witnesses, etc. The opening statement is the only chance you have not to start arguing, but to tell that story in a form that's bigger than the theory, right, and smaller than this whole trial you're going to put on. Does that help? All right. Now, why is this important? Well, if you were in here in the morning, like Arthur was, you would have heard about how we're going to get all our decisions in voir dire. All the questions we ask are going to be tied to this theory of the case. We're not going to ask it under this theory. We're not going to waste our time asking fungible questions. We're not going to ask about things like reasonable doubt. We're not going to ask how many people are on drugs. Maybe I'll do that with a jury question. How many people in the jury are on drugs? I might do that with questionnaire. But I'm going to prioritize the questions I ask in voir dire to move my theory of the case, right? Okay, and I'm not going to do the voir dire lecture now because we don't have that much time, and I've already lost 15 minutes trying to do this, but we can't understand what we're going to do unless we do it this way. Now, any questions so far where we are? All right, now, I want you to understand that with regard to this, everything that you're being taught here at the National College about how to ask the questions, short declarative sentences, one fact per question, looping, no non-leading questions. I'm endorsing all of that. I'm taking that for granted, right? But where we're moving now in cross-examination is, how are we going to be able to take the people, some of whom we would have called even if the prosecution hadn't, right? Some of whom we didn't want to call, but now we have to. How are we going to make them effectively part of our case, right? And a simple example is, if I put my hands on another theory, I probably can't on me. Okay, really simple theory. When called into the gas station, Gary Conister was shocked to discover his friend, Adam Burnett, had stabbed the gas station attendant and was pointing a large knife at him. Terrified and confused. Notice, you are writing in the vocabulary of your story into your theory. Terrified and confused, Gary, fearing for his life, obeyed Adam's commands to take the money and give it to Adam. Under these circumstances, I don't like this last part, but under these circumstances, Gary is not guilty of any crime because he was forced under threat of bodily harm into participating in the robbery. What is the instruction in most jurisdictions you're going to ask for? Compulsion, coercion, and duress, right? And so inside these facts is also a legal component, right? Dominant emotion, maybe fear here, right? It sounds like it might be fear. Your boy, Gary Conister, it may be surprised, was shocked to discover. So your whole idea is, here's Gary and Adam, right? They're going on a road trip together, like a bad movie. They stop at the gas station. Your man, the defendant, is out there pumping the gas, right? The other guy goes in. Got finished pumping the gas, maybe he pays by credit card, maybe he's going in to pay, or maybe he thinks his buddy's paying, and he walks in and a robbery's in progress, right? But what do the people see? They're in there. They see the guy, the co-defendant with the knife, turn and say, get the money. They interpret it, they're working together. Your version of the story is, man, he didn't even know this guy was going to do it, right? See what we're talking about? So this is the story you've got to tell. Now, or this is not the story you have to tell. This is the story you've chosen to tell with this theory. Now, this is a really simple example. They call a police officer in, who went out there after the fact, did the interviews, etc. He takes the stand, and some of you might tell me that you may have a funny rule on cross-examination, that you can't go into anything on cross that they didn't go into on direct. So if not, then you just call him back as your witness, okay? There's no rule against that, but he will already have been sponsored by the government.
I'm sorry, I guess what was the last point?
Then you call him yourself as part of
You
your
call
case.
yourself, oh,
Yeah.
okay.
But I never run into that problem. I'm allowed to go farther with him. Anyway, so you say to this guy, now I'm not going to go through the technique, I'm just going to tell you, before I go to the technique, I'm just going to tell you, so you're talking to this guy and you say, part of your job is to go out to places like banks, fast food restaurants, gas stations, convenience stores, etc. And you tell those people about what to do when they're robbed. When somebody comes in and demands the money, you tell them what? What's he going to say? I mean, I'm going to put it the words in his mouth because I don't do it the NCDC way. But what is he going to say? You don't know?
I don't know. Give him the money.
They're always telling me. This is, I mean, you could go get the manual if you needed it, but you don't. They will always tell them, don't protest, don't fight, cooperate absolutely, do exactly what the robber is telling you. You see how this is going to move your theory of the case? And now what you have is a guy or a woman called by the prosecution wearing the blue coat, right, or whatever they are in your jurisdiction, endorsing your theory, right? And that character that was brought in for some purpose unrelated to your story, or tangential or minimal in your story, you've now made him important in your story and helped him to move your theory of the case. You've got to give him a different character through our cross-examination. You see it? Okay, that's an easy example. Now, just so you get something out of this, And again, I apologize to you guys that were with me in cross-examination, but let's talk for a minute about the marquee question, because I kind of used that as a hook to get you in here. When I stood up, is that right? Did I do that? Okay. What's a marquee? You know what a marquee is? Anybody know what a marquee
Sign,
is?
lit up sign,
A lit up sign. What it's usually over.
like a theater or something.
Right. Okay. And what's usually on it?
Like who's playing or what movies are playing or
And
what's going on inside.
What's going on inside, and then sometimes, and this was more when I was growing up than probably now for you, it was sometimes say what's coming. Okay. That's what I'm talking about. What we do with, what I want you to do under my theory of cross-examination and this whole storytelling methodology of litigation, I want you to have a marquee over every one of those people you cross-examine. And what does this mean? It means, ladies and gentlemen of my jury, that I don't think you should get up and say, "Good morning, Mr. Prosecution Witness. I'm going to be asking you a few questions today." No, shit, I thought you were going to come up and deal me stud poker or something. I don't know, right? So why would you do that? Why would you stand up and waste time and bore people and cause jurors to think, "I don't need to listen to this," right? You've got, psychologists tell us, in these kind of situations, you've got 20 seconds every time you stand up in front of somebody to get their attention. So we need to get their attention. And when you did cross-examination the other day, right, yesterday I guess it was, you probably did some creative things to do that, did you? Did you do anything, or did you just start like that?
Well, we kind of started in the middle
Oh,
of
okay.
the cross-exam, so
See, okay. I want you to look at this as this first impact with this witness, right?
but I normally get up and introduce myself and say, I'm going to ask you.
Each time?
Yeah, usually.
Yeah, you can imagine what the jury's doing if you cross-examine 6 people. Every time you get up and introduce yourself to the witness, what are they thinking? How many times do I have to hear this guy tell somebody who he is? And you're doing it because you think it's good with the witness. But you have to always be conscious of the only person that gets a vote are the people in the jury box, right? And that's who you're really trying to deal with. And you want this to be a good experience for them, not a bad experience. I don't mean to be harsh with you. I'm just trying to tell you. Think about it that way, right? Okay, so what are we going to do with the marquee? Okay,
I
go
actually
ahead.
have a question I was thinking about.
I know you've been studying up to get me. That's why you came.
That's why I came back.
He was in the group yesterday. Go ahead.
When you ask a marquee question, where you ask a question where you don't introduce yourself, especially some law enforcement officers might have to do this. What's your name, or you know, like?
Okay, well, remember we talked about Columbo?
Yeah,
Okay, didn't we?
yeah.
Talk about Columbo? You guys know who Columbo is?
TV.
The TV show, you ever see it? And even on TV Land? Yeah, I'm old enough, it was the first run. You don't know who Columbo is? Peter Falk played Columbo. Columbo's character was, he was a great cop, right? Great detective. He always wore, it could be sunny in present, he always wore a rumpled raincoat. One of the, right, you know?
Yeah.
A London fog, rumpled raincoat type, right?
Right.
Probably was a cheap imitation. And he always, no, he didn't flash. You would like to see Peter Falk flash, I could see that, okay. No, you don't even know who Peter Falk is. But the whole idea was, his approach was, look at me, I'm a stumble bum. And he'd always, like, he'd be talking to the guy who was suspicious of the woman, and he'd start to leave. Well, thank you so much, just one more question. And he would zing it. So sometimes you have to be Columbo. And I use Columbo for this. Or I guess you ought to be Columbia, the women in the group. What I use it for is when a judge is going to be such a jerk, or a witness does what you're talking about, you have to get a new opportunity for the first 20 seconds. So in that situation, if the guy interrupts you, what's he going to say? Tell me what he said.
You get up and ask them like a question
I
without.
started to ask the question.
I'm sorry. He'll say something like, "I'm sorry. What was your name?" Or you know.
Okay, so then you tell him your name, and you just turn around, walk over to the table, or if you're sitting at the table, fiddle with your papers. Sometimes I do it long enough for the judge to say, "Mr. April?" You know, it's just a second, Your Honor. And then I get a chance to start all over again, right? I've got new primacy, and I've got a new 20 seconds to get the jury. So that's how I deal with that. There might be other better ways to deal with it, but that's what I'm saying. We need that opportunity. Now, I suggest to you, because I really believe what they've taught you here and what all of history seems to indicate from speeches that were made a long, long time ago, trilogies, speaking in threes are really important. Could you have a marquee question that was only one question? Yes, you could. I think it's probably better to try to do it as 3 questions. I'm going to read you one example. I'll make it easy for you because at this point in the week you now know about the Mario Dodd case, right? Even if you don't have it, you know a little bit about it. So let's say I'm cross-examining Judy Dodd. Here's, for my theory of the case, for what I'm going to try to do with her, and it would not be the same if you had a different theory or a different way you're approaching it. These are my questions. Ms. Dodd, you have no reason to mislead this jury today. Wait a minute, Vince, are you nuts? Are you truly nuts? See what I'm doing? Does-
You're going somewhere with it.
Do you think that she expects that, having been prompted by the prosecutor? Well, maybe if you start doing this with every time in every case, the prosecutors will know, don't, and they'll say this, it won't help them. They'll say to their witnesses, this lawyer, Vincenza April, is quirky and strange. She's going to ask you questions that you're not going to expect. And I can't tell you what they're going to be, but don't be surprised, right? If it doesn't sound right. Anybody want to argue with me so far about this? You're free to, you know. Ms. Dodd, you have no reason to mislead this jury today. Ms. Dodd, you have no reason to falsely accuse your husband, Mario, of being involved in this bank robbery. Ms. Dodd, you have no reason to lie to this jury today. You with me so far? Mm-hmm. Now, how do you say it? You could go up there and you could say, Ms. Dodd, you have no reason to lie to this jury today. That would not be good. You don't need to be mad. You want to go up there and you want to do it very nicely. Almost like you know, do you really mean this, right? You have no reason to mislead this jury today. So what are the answers you're going to get? What do you think? You've got 2 choices, yes or no, maybe 3, maybe. So she says, no, I do have a reason to mislead this jury today. Okay, that's fine. We'll work with that, right? But we anticipate, notice these are flattering questions. These are not mean and nasty questions, right? So she's probably going to say, that's right, Mr. April. I had no reason to mislead this jury today. Our cross-examination is going to demonstrate that she has that reason, right? Okay. Now, we went through those 3. Get a feel for it? So, simple example. What about when you're dealing with a police officer and you're going to go into some form of that person not doing a good investigation? I hope I'm not warning you guys too much. Okay. What do you think the questions might be?
How great they are at their job.
Okay, and how are we going to put that?
You worked for a long time, you trained to do your job, you're
Worked for a long time, trained to do the job, what else?
detailed in your job, accurate in your job.
Now, you don't want to go too far in the original questions into how you're going to later expand. Yes, sir?
What about you want to do a good job, you know, you're professional, you wanted to do a good
Okay,
job.
well, there.
If they're like an armed robbery detective, you say, well, you're with the armed robbery division.
No, not yet. 'Cause you're going to do that.
Okay.
This is setting that up, okay? And that's what I was saying when, it's Rick, isn't it?
Yeah.
When Rick started going past the second question, he was getting a little more into the details that will come. What we're trying to do is almost make them general category questions. So we got some good things here. We got expressing like this. You are a trained investigator. Now you change it depending on your theory of the case, but this is where you're going. You are a trained investigator. You are an experienced investigator. You understand the importance of a complete and accurate investigation, or some other words that you like to fit that. You see what we've done? Now, you're going to do this to the person if you're going to expose how they screwed this up. And why are you going to do that? Because you don't, you know, if they say they're not, it helps you. If they say they are, you're going to let everybody see how they know how to do this the right way, because What are we going to do? And that, what we are going to do with all of these is the basis for putting the witness in context. And that is going to be, we are going to impeach them and get to the important thing with who they are. If they try to wiggle, if they try to lie, if they try rationalization, what's the jury going to say?
Full of shit.
I can't believe you're saying that. That's not you. I just learned who you are. And you told us earlier in the examination exactly who you are. That just doesn't fly. I don't believe you. Why are you saying that? And that's what I meant when I said you impeach people with their personality. And what happens when the prosecutor puts on witnesses? They don't give them personality most of the time. They might the victim. You know, if the victim's alive, it's hard to get the, well, and they might, I shouldn't say that. They would in a death penalty case, try to get a murder case, try to give some personality. But for most of the people, they don't care about that. Every once in a while they do, but they don't, mostly. So you got a flat picture of this person, only what they did that's important to the case. You're changing it, you're turning it around. Wasn't that what we're doing with Judy Dye, with those questions? We're setting it up to be able to show what her personality is in our story and why she can only act one way in the situation we're going to talk to her about. Is it making any sense at all?
Yeah.
Okay. So, do you understand now why I say there's not a fungible question here? I can't give you, I mean, you could probably use with police officers that did investigations, the very similar marquee questions. But when you go to fill it out, it's going to be different every time, right?
I get what you were saying about all this, but it seems like,
Go ahead.
I mean, is it good, so basically try to build them up. Initially, when you get out there and you start your cross and you have that witness, you try to build them up and kind of feed their ego, and so they basically tell the jury how great they are, and then you ask your questions or you leading questions, so to show them that he's not as great as he says he is.
Well, you're going to ask, you are going to testify as the cross-examiner as to things that are supported by the facts. What you are really doing is putting them in a position where if they try to make excuses, try to run at you, try to do their own agenda, they're going to look exactly like somebody who's not interested in telling the truth, somebody who is interested in convicting your guy at all costs. That's the kind of thing you're trying to do. Now, I have to tell you, let me see. What's your name again?
Marcos.
Yes, I thought it was. I didn't want to say it'd be wrong. You did the kitchen one or the other one? You did.
The baker.
You did the Baker one. Second time he did it, he did this perfectly with the officer. He did it so well, and he went right on through it, and the officer was just really trapped. And he actually even acknowledged that. But he did it the way we're trying to talk about here. So I'm not trying, this may sound like it's hard, and I know I haven't fleshed it out as well as I need to in the remaining 25 minutes, and we're going to keep going on it. But it can be done. It is not something that's beyond your abilities at all. Did you feel like it worked for you when you did it? Okay. We had some other people in that group who did it too, really well. Okay, so we're talking about some examples of marquee. Why is the marquee important? Because you're going to use it. You're going to use it again and again during that cross-examination, or you know you have it to use it. So when you talk about experience and the person tries to get away from the experience and do something contrary to the experience, you can say, but you're an experienced investigator. We agree with that. You've already told us that. See what I mean? All right. Now, here's the hardest part. And we're not finished with the marquee, but since the time is rushing by, here's the hardest part. How do you accomplish this? You hit on it. You understand where I'm going when you made your statements a little while ago, or just a second ago. You have to do it up front. It's a lot of front loading that is involved, and a lot of thinking this stuff through. Most important thing maybe that I could tell you about litigation is this, and lawyers don't want to hear this. Conclusions don't persuade. conclusions don't persuade. What does that mean? When you get from that police officer, you feel really good when you get to police early in an examination to say, yes, when you say it's important to have an accurate and complete investigation, you feel like you scored, you feel like you've won something, don't you? Don't you? Come on, tell me.
That's where you're headed, yes.
But I mean, when you get that, I mean, let's say you don't do any marquee questions, the first thing you said was, hey, can we agree? It's important to do a complete, and you wouldn't ask it like that because it gives you wiggle room, but what I'm saying is, it's important in every case to do a complete and thorough investigation, yes. A lot of lawyers stop right there. Now all they want to do is rush over and show that you didn't do it in this case, right? But here's the problem. The jury has missed it. If they heard it, they don't care about it because it doesn't mean anything to them. It's a sentence, you know? They're not thinking about, why is that persuasive? So your job is to make it persuasive. What's your name?
Mike.
You did the other one, didn't you? Were you in my group yesterday?
Not too.
Okay, I'm confused. The other guy, I didn't want to leave the other guy, because that really good one of kitchens. He's not here, right?
No.
Okay. I'm sorry. I'm just trying to be fair. People work hard, do a good job, I want them to acknowledge it.
I got smoked on
I'll take
kitchens.
credit for it.
Huh?
I got smoked on kitchens.
All right. So, here's the thing. You've got to think of how to make the jury appreciate, and I'm using this example because it comes up a lot. You've got to make them appreciate through the government witness, that police officer, why it's important to do that, to do a complete and thorough investigation. And how do you do that? What kind of questions do you ask? What do you think?
Like, everyone that relies on it.
Say it loud so we
Oh,
can hear.
you go through all the folks that rely on it, and,
But see, and I know you're not saying this, Michelle. I know what you're saying is, you got to go through this. I want these people to hear that it's okay to say this. Many people rely on the reports you write. Right? Because that's a conclusion, and that's a little better than simply saying it's important to have complete and thorough investigations. But you still haven't done anything. The jury is there to be taught, to be instructed, to be entertained, so that they understand the significance. So, who relies on the reports?
Other
The what?
other cops,
The
Prosecutors,
DA,
defense
prosecutor?
attorneys.
Other cops.
Other cops?
the judge.
Press.
The press? What other uses?
That
Oh.
cop,
What?
that same cop's gonna look at it again.
Yeah.
Preparation for court.
Preparation for court. So now, each one of these things becomes a separate vignette for you to develop. And how do you develop when you're talking about that the officer himself has to rely upon? What kind of things would be important to show how he needs to have it written down somewhere and can't rely on his memory?
A lot of time passes. From
A lot of time passes.
They do a lot of cases.
He's got a lot of cases. How many cops, how many sheriffs, how many FBI agents, you're going to say, now you only have had one case in the last year, is that right? Well, no! Right? I've got 100 cases going on, I've got 1,000 cases going all the time, right? You're not going to have any trouble pulling that. So you want to get that out. So, you got a whole lot of cases, a lot of time has passed. Anything else?
A lot of facts.
A lot of facts, a lot of details that are in these reports. See what we're doing now? Now the jury is starting to think, okay, that makes sense. You can't trust your memory, right? Now you want to go another place, perhaps, and I can't think of all the things you can think of, but I want you to get the process, right? So, what could happen that would take out, that would be harmed, I don't want to say it, I'm trying to give it away. What kind of circumstances could occur that would really make a bad situation if all the facts weren't in the report? What?
The explanation.
The explanation, yeah, but I'm talking about what kind of things, what kind of intervening circumstances could occur?
He dies in line of duty.
He died in the line of duty. Try not to use that. Try not to emphasize that. It's a cocktail case. But that's right. That's absolutely the best one. I mean, if you don't have a problem in your theory of the case with it, to say to that officer, you put your life on the line every day, right? That's what being a police officer is. And because of that, we all know, God forbid, you could be killed tomorrow in the line of duty. And if you don't say at that point, and if that's not in your report, you don't want to do that. You're just getting this information out, right? And so the jury hears that. You could get another job, right? You could move across the country. All those other things. You see what you do? And so you're just boom, boom, boom. And it's not really, and you're not doing it, this is a hard thing for lawyers to appreciate. You're not talking about your specific case at that point. You're talking in general terms. It's not confrontational. It's not about this case, and you do it in a flattering way.
What about, like, I know we're not really supposed to ask too many open-ended questions, but you start with saying it's important to do thorough and complete investigation.
Right.
Of course he's going to say yes. If you say, can you tell us why it's important, that's an open-ended question. But if he can't come up with any reasons, he looks like an idiot. And if he does come up with some reasons, he's kind of doing your job for you because those were the leading questions that you were going to ask anyway. And then so it kind of makes it a little bit harder on that witness. Or do you see any problems in asking that specific open-ended question?
Yeah, I see the problem.
What's the
One is you don't want to give him the control of this. That you are moving, you want to tell the story. You know, and when you have your witnesses that you're calling, you can tell them. You know what they're going to say, and you prep them and work with them, hopefully, so you know what they're going to say. Could you do it that way? Yes, but it's not a good idea, and it's not a good idea for a number of reasons. Now, you think it sounds good because it's like we said about, not in here, but about voir dire. When you get these people saying the things you want to hear, everybody knows that you're not saying it. You didn't put them up to it, right?
But the only thing I can foresee is if he started getting specific about that investigation and saying how great this investigation is.
Exactly. That's one. But there are all kinds of downsides. So what you do is, even if you don't know the answer, you can put the things out there. Like, you don't know how many cases he had, you could say, and you carry at any time a large number of cases. You can suggest a number and he can contradict you. I don't mind that. He could say, no, it's much more than that, right? Or not quite that many. I don't care. That's not losing control. So you can accomplish all of this. You put it out there and he may run on you or she may run on you at some time, right? And give you something that you didn't think about and you can use it. That's fine. But I have to say, I was like you, or maybe you're not, I shouldn't say it. When I came here, I'd done a lot of cross-examination using branching and open-ended questions. I was good at it, I thought. But I have to say, I can't find any reason not to do it this way in cross-examination, the way the college teaches. Anything I can do with an open-ended question, I can do just as well this way. So I'm trying to say, I would not do that.
I mean,
I'm breaking the habit.
I mean, you could get burned on that too if you were
Oh,
like,
yeah.
fair to say you've done
Right.
50 cases since then, and they're like, oh no, I've only done 3. All of a sudden you made this impression that it should be much more than that.
So that could happen. That's why you don't rely on one factor, see? So he's got 3 cases, and that's all he has. He's broken his leg, and now you're going to talk about, you've also got the passage of time to talk about, but she's also got that it's not so much how many cases he had, it's how many cases he could have. It's just as important, you see, because what you're saying is at the time you were collecting the information, right? What were you doing? You were recording it because you didn't know how many cases were. So it's important because the cases can grow and grow. One case can be very, very big and take all your time. You have massive amounts of information. You can't trust your memory. But you're not going to say that yet. But you're going to get those kind of things out. But that's why you brainstorm all these different approaches to put in there. Now, what you're saying to yourself is, this sounds like a long cross-examination, right?
Yeah.
And it is. But it works.
Seems
And
very-
the other thing,
Seems very detailed.
It is. And that's what convinces people. And as I was saying in the group yesterday, you must take the baby steps. You must take it step by step. If you rush to the conclusions, it loses its persuasive value. So it's gotta be done that way. Okay, go ahead.
I always get the police officer that says one or two things. Either I forgot to put it in my report, but I remember it now.
Yeah.
I mean,
That's what we're dealing with, aren't we?
we?
But isn't that what we're dealing with? I'm telling you that you are going to talk to this guy, and you're not going to even talk about that report. You're telling him, you're having a conversation that you're doing all the talking in, and he's saying yes, in which the jury is hearing how he would never do that. He would never do that for all these different reasons, right? So when he then, and he is going to do what you said, Arthur, he's going to do it. You're going to get there, and when you confront him with the fact, you testified to this, but you filled out all these reports, and it's not in there. You're going to let him look at it. You're going to say, tell me where it is in the report, right? To dramatize it. He's going to look at it and say, well, it's not in the report. But I didn't need to put it in the report. It was so important to me, I would do it. And then, that's what we did all this work before, because the jury's going to say, he wouldn't do that. He wouldn't do that. He wouldn't do that because
He's not trained, he's trained to do.
he's trained how to do it a different way.
Right.
We didn't even talk about, you know what, you talk to them about this too. See, I don't have enough time to go into everything, obviously, but you say, and you didn't start off as the first assistant sheriff. No, I didn't. You start off as one of the, what? A meter maid. You were a fucking meter maid. And then, but then you say, so you have been promoted over the years. And you are promoted based on how well you do your job. And your reports are reviewed randomly to see if you're doing a good job, compared with the results and things like that. So you know, when you're writing out a report, you're going to be judged as to your performance every time you write a report. You see what I mean? Now it's an economic incentive. You're filling out all of these things, and the jury's going to say, this just doesn't smell right. Doesn't smell right at all. Yes, sir.
Okay, one of the things I try to do is say, did you go to the academy, weren't you talking?
Yep. We're talking about that, Arthur. We're talking. That's why I said the first question was what?
Experience.
Education.
Right.
Okay, it could be experience, but
Okay.
one of those three questions
Okay.
is education. And
Okay.
you're right, Arthur, but you know what? Don't do this. What you're doing is absolutely right, but I hope you are doing it in the detail I'm talking about. If you're just saying, at the academy, that you went to the academy or you were trained, however it is in your voice,
All
you say it, you went to the academy, you had courses on how to write reports.
Okay.
And they told you those reports had to be complete and accurate.
Right.
Now I've taken care of that. Bullshit. You haven't. It's not enough. That's what I'm saying.
Yeah, well,
You got to build it up more
Okay.
because jury has got to understand how significant this is, right?
Okay, well, now I know about error my way. That's the way I was doing.
Good instinct. Good instinct.
Will
What?
you build it up a little bit more?
On that one, on education?
Yeah.
Well, here's what I like to do. I like to not just talk about report writing when I talk about the education. I'll start off and say, so you were trained in the academy. At the academy, they taught you how to examine a crime scene. They taught you that you have to look for physical evidence. You have to look for things that, even if I don't have this in the case, I'm going to probably say this. They're going to tell you to look for things that might be a way of identifying who was there in that room that might have been involved in the crime. So you're going to have to pick those up. You're going to have to mark, if that's your job, you're trained, then you know how to mark them, to preserve them, put them away. And the reason why you're doing that is because it's vitally important. So, we're not even talking about a report. It's vitally important, isn't it, that people will be able to look back and know exactly where you picked this up from, that they will know exactly what you did with it. So we're talking about accuracy and completeness in other contexts. You don't want to just walk up to them and make it so focused and so tunnel that they're on guard, right? So you talk about these different things, and that's how you're building it up. You get that? And then you move and so reports are in there too. Okay? And then you move into experience and you do it all over again. Look like you're a little skeptical.
Yeah, we,
Are you skeptical?
no.
No, I mean, I think I just need to work at it.
Oh, yeah, you do. You
I
do.
mean, it's, like, that's one of the things that's tough about these kind of things, is you gotta think outside the box. You
That's
gotta come
right.
up with these little
Exactly.
things. And sometimes, we didn't go to the academy, we don't know what they taught them, we don't know, you know what I mean? So it's like, that's why it's helpful to hear some of the
Oh,
things.
yeah, right, yeah, it is, you're absolutely right, and it's also good to just sit around with people, you know? I don't know you, but I bet you've had a beer in your life, and you might have had a beer with some of your colleagues, right? You could sit around or at lunch or dinner and talk about these kind of things and come up with, like you say, brainstorming, either formally or informally. You might want to talk to a police officer, retired police officer, but on most of the stuff, you really, if you think about it, you can come up with it yourself. But you're right, it's not immediately on the tip of your tongue. It's not something that you want to think it through. But the bigger thing is to try to expand it in your own mind, right? Okay. So, the police one is, all right, let me give you the example from, see what you think about this. In the case I read you about the little girl, the Joey Burden case, there's a doctor. The doctor examines the girl the next day, and what does he find? He's got these, looking at these incredible bruises. There were some abrasions, but they were very, very tiny. They were right here, okay? And they were funny kinds of abrasion. I found all the articles I could find online. I mean, it wasn't even online. It was through the medical library and the periodicals there. Made a request. Got stuff on that, and I knew a lot about abrasions. But he reported what he found, abrasions and bruises. He sent her off for an x-ray, which was negative. But when he comes into court, just like I knew he would, he wants to talk about how this girl was beaten and how this show, you know, how she was hit and how all of this shows it. And so the marquee questions for him were, number one, doctor, you're a man of science. Number two, doctor, you're a healer. I said this before, don't do that with a pathologist because they don't do any healing, right? And thirdly, the doctor, I don't like smiling at him, you're not a detective, are you? And if he says he's a detective, I don't care. You know, but I'm putting it that way, you're not really a detective. Now, what did we do? We went through and discussed the scientific method in front of a jury in Muhlenberg County, Kentucky, which isn't exactly Louisville or Lexington or even Ashland, right? Small town, talked about the scientific method. We talked about how you have to do things scientifically. And you're a doctor, you're a man of science, right? So why do we do all that? So when he started to editorialize on the basis of what the mother said happened, whoa, doctor. Now you promised me, I didn't promise me, you promised the jury, didn't we? That you were a man of science and you're here as a doctor, a medical doctor, to talk about science. You don't know what she tells you is true or false. So we're not going to talk about that. Let's talk about what you really could do. And that's how we did it, see? To diffuse what he was saying about the bruises. And to show, I mean, I can just tell you, he tried to say those bruises would show, and you've had doctors do this, I'll bet you. Now, if it's somebody who's, the bruises on a dead person, it can be a bigger problem. But on a living person, when they say, that's the imprint, the bruise is an imprint of being hit, there's a whole lot of reasons why that's probably not true. Because underneath the skin, the broken blood vessels come up against these almost like dams or walls under the skin, which cause the blood to flow other places. So when he started doing this, I kept saying, doctor, I didn't even have an expert, right? I'm saying, doctor, you're aware of, I think it's called fascia, F-A-C-I-A. You're aware of fascia? Yes. And I said, and in truth, isn't fascia like a dam? Isn't it like a dam that stops the flow of blood and diverts it someplace else? And what do we see with a bruise, doctor? What we see where the blood has moved around under the skin, when the blood vessels break and it comes forward. And so got him to the point that every time he tried to say, but it matches up, but doctor, you have no way of verifying. cause of the foster. The jury's over there. You with me? And every time we're back to the man of science. This is science, doctor. You're not speculating. You can't speculate about this. On the healer, they try to set part of the elements of the crime involved that she was put in pain, right? Her mother didn't give her anything. And I asked him, when you finished seeing her, you prescribed one thing, didn't you, doctor? You prescribed an x-ray. Doctor, does an x-ray, you prescribed an x-ray. Doctor, does an x-ray cure anything? Doctor, does an x-ray relieve pain? You see what I'm saying? But and then you say, so doctor, if you thought she was hurting, if you thought she was in pain, you would have prescribed something for her. Or at least told them to get something over the counter for her. You didn't do that. You didn't do that. And you would have, because, doctor, you're a healer. See where we are? Just keep coming back. And at the end, doctor, you're not a detective. But before that, he said to me, you're the expert. I can't talk to you anymore about bruises and abrasions. You're the expert. Well, I want that. I'll take that.
He told you that you were the expert?
He said that. He said, you know more about this than me. Because I beat him to death. And I didn't even have my own expert. Okay? That's preparation. I mean, you couldn't do it just by guessing, but it was preparation. And you know what? You know what we proved? You know, you didn't have to prove anything. I proved that the abrasions, you know what they were? The zipper, when she fell forward. The zipper, she hit. She's a little kid, right? She's walking up wooden steps. This was a mobile home that had been made permanent, and they had wooden steps. So she falls forward under our theory. She kind of falls down. That's how she bruises her face on the steps. And the particular type of abrasion was where the zipper on her coat went boom, boom, boom.
Can I ask you a question?
Yeah.
I know we're almost out of time, but, I mean, you've been
I haven't
saying,
done enough, I apologize.
no, you've been saying that, like, an ME would be different, a dead body would be different, blah, 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 that kind of thing.
I only said it was different because you wouldn't say you're a
Right,
healer.
you're a healer.
Right.
And, I mean, my understanding is MEs do kind of take into account of what people say happened at the scene and stuff like that. I'm just wondering, and this may be putting you on the spot too much, but if you could give us like a marquee for an ME.
Okay.
Like on an autopsy or something.
Tell me what you're going to do with the medical examiner. Who's got Dot in here? Anybody? Dot. I'm sorry, it's not Dot, it's Kitchens. What am I thinking of?
Oh.
Who's got Kitchens? Okay, you got that great autopsy report, right? What would you do? Is there an autopsy report?
Oh, yeah.
Okay. So what would you do with that autopsy report? I'll probably give away stuff for next week.
Yeah, I didn't.
Who knows what's in the autopsy report? Anybody?
The trajectory.
Phrase knuckles.
Yeah, trajectory, the knuckles.
Tell what?
The trajectory, the bruised knuckles, the track marks.
Trajectory of the bullet.
I think you were
Blood
talking,
alcohol.
you're trained to make observations.
What?
You're trained to make observations, to record those observations, to report things.
You might want to say, with all of this stuff, you might want to say, if you're going to turn it into your witness about all those things on that report that help to support that, doctor, you're a detective. Doctor, you're able to reconstruct who a person is from their body. Now this is what I'm saying, I'm going to make this person really favorable. And what you're going to do is, remember, what do you got? You got a gigantic liver in that guy, right? Well, why is that a gigantic liver? Because he's a drunk, right? So if you built, and I don't know what your theory is, but if your theory was that way, you might want to elevate this guy. You know, even though he's coming in and saying bad things, some things that the prosecution thinks is bad for you, like how this guy died of a bullet, well, you don't give a shit about that. Your theory is she shot him, right? And you may disagree with, you know, what they're saying. You might be going to show that he's wrong about the trajectory or something like that. I don't know. But if you're going to really use him to build for you, you could start off and make him a detective. You could make him somebody who can read. You don't even want to say, you are able to read a person's personality from examination of their body. I mean, you see what I'm saying? And now you're building him up that way. If he says no, you're still going to show that that's what he's going to be doing when you take him through it, right? But he's probably gonna say, I like to think I can, Mr. April. Does that make sense? There's no limit on this. I feel like, I normally do this 2.5, 3 hours, and I'm just really getting started. But by using those examples with you, I mean, I know we gotta stop. I'm just thinking, with a person with a prior inconsistent statement, if it's really important in your theory of the case to impeach a guy with his prior, or a witness with a prior inconsistent statement, how about this? You are an honest man. You are a man of your word. People can rely on what you tell them. See what we're going to do? He said it differently other times. People have relied on it the other times. And what you're really saying is, you're a dishonest guy. People can't rely on what you say, right? You're going to take them through, and when you're talking, when you get to the part about talking about what you said previously, and those people relied on what you said. They believed you to be an honest man. You testified under oath. See what we're doing? So these 3 magic questions help you to do this, but you can't do it until you figure out the person's character inside your story and how they move it. Last thing, because I kept you too long, and that is this. I used to think that you could just look at some people that the prosecution put on and stand up and say, maybe in a really cool way, I have no questions of this witness, like you're disgusted. But you know what? You can't do that. I used to do it pretty well. But what you want to do is always make sure that you ask enough questions in cross-examination that the jury understands nothing happened here that makes your theory of the case implausible and not workable. Okay? And in fact, moves it farther on. You guys have been great.
I got one quick question though.
All right.
Are you saying that in all, I mean, you're not saying that in all cases, that you have to cross-examine every witness that the prosecution calls?
Yes, I am.
You are saying that?
I'm saying that for the reason I just said, and you know what? They're a character in your story. You better make sure the jury, you will just think about that you ought to be getting your stuff together. You're going someplace else. If you're staying for ethics, I'm going to be here. A juror is in the deliberation room. He says, you know what? I think this case turns on that one witness and what he said. And you know what? That defense attorney didn't even ask him a question. You haven't helped the other jurors to be able to say, wait a minute. Sarah specifically asked him this and this. And you know what? That fits with exactly what they told us in closing argument, even though they didn't refer to it. You can't let that go. You got a person's liberty in your hands, right?
Right.
Okay.
Thank you.
Thank you.